whatever provisions where the overlapping is there would get repealed in the due course? Do you feel that?
So ideally, that is what states should be doing in due course of time. Either they should align, the provisions in the Shops and Establishment Act with the requirements of labor codes, or at least they can have those provisions which are overlapping to be repealed in due course of time. Complete abolition of Shops and Establishment Acts looks very difficult, Akhil, because there are a lot of provisions which are overlapping, but there are provisions which are not overlapping also. There are other matters which are being dealt by Shops and Establishment Act. So it will be there, but we all of us as an industry, we expect that some sort of repeal or alignment happens for the overlapping provisions.
Understood. And Ankur, as you rightly said, within 2 working days of exit, clearances of dues, there's a concern on the recovery of assets, and calculation may not be possible. So, I believe, I don't know whether this is a right interpretation to take or not. You can clarify as an expert that the two is like 2 working days from the last date of the notice period. If a person exit, apply, file a resignation. So we have 3 months or 2 months notice period which we've generally seen. So that's an ample time which government has already given to the organizations to prepare and ensure that from the last date of the full and final settlement, it should be paid within 2 working days. Don't you think that's an ample time, or do you think that we should have some other way around it?
No, Akhil, there is a ample time. It is more about, re-engineering your existing processes. Because
Yeah.
if law was always there to settle it within 2 days, that is what would have happened, right? It was not there earlier. It was not governed by strict rules. So that's why there was a 30 to 45 days of window which organization used to take. So some rearrangement there. Obviously, asset recovery is a big challenge. For that, some clarification from Labor Ministry will be welcome, because then you have to withhold some of the amount, right, for asset recovery. So the practical side of it, it will evolve. The practices are going to evolve as in when we move ahead in this journey.
Yeah, I agree with you because it's been 20 years, 2 decades when this journey has started. And when this law was written, they were not aware about COVID will happen or work from home or hybrid working will
Right.
happen. So that's the reason this asset recovery in 2 working days is practically impossible. Thanks for your time and giving your perspective. Now I would request Rashi to throw some light on other financial implications for the employer.
Right. I think in terms of the financial implications, the very first point is gratuity, because provisions for gratuity have been there in the company's books. That is something which the accounting standards requires us to take. Provision for gratuity is put together based on the current definition in the Payment of Wages Act. Whereas in the Code on Social Security, with the change in definition of wages, the wage amount will most likely be higher than only the basic in most organizations. Hence, there is a impact on the quantum of gratuity that would be paid to the employees. Before we come to some practical aspects over here, just to outline what the new provisions are going to be. Uh, First and foremost, there is no change in eligibility, which is still 5 years time for permanent and regular employees, for where there is no end date to their tenure. So 5 years or exceptional circumstances like death or disability, those provisions still remains. One of the key change is in terms of applicability of gratuity to fixed term employment. Now, fixed term employment, which is eligible for gratuity here, means where the services are rendered under a contract for a period of 1 year or more, like a 2 year contract or 18 months or 24 months, and so on. In this case, the completion of continuous service of 5 years will not be applicable, will not be required. Now, in case of an employee who's on a fixed term employment, the employer will be paying gratuity on a pro rata basis, even if the contract ends earlier. So, if it's a 2 year fixed term contract, if the contract ends, say, in 18 months because of the project completion or any other such reason, then also the eligibility for gratuity would be there and it would be calculated on a pro rata basis. Now here, Social Security Code also defines the fixed term. In terms of fixed term employment, there would be a proper contract. The contract would mention the end date, and based on that, that's how we differentiate between what is a fixed term contract employment and a permanent employment. And this is not to be confused or mixed with consultants or such independent consulting or contract arrangements which companies have with individuals. Those could be consulting contracts with professionals or others, which is essentially not an employer employee relationship. So those arrangements which are consulting or contract in nature and outside the employer employee relationship are not considered as fixed term employment. Fixed term employment is the regular employer employee relationship, but with a fixed term of engagement with that entity. So, hence, I think employers where now we see a lot of fixed term contracts also. So, that is something you would need to review and make necessary changes or bring in that gratuity provision for the fixed term contracts as well.
No, I think that's very useful information for everyone, and I have a lot of questions on that. But I'm waiting for Dr. Meena to join back. I don't know whether he's joined back, though he's connected still, but his video is not visible. So I'm waiting for him to join back and have questions to him on this instead. Thank you, Rashri, for the clarification. This will certainly help the organization to comply with the law. Now I will ask Ankur to talk us through the changes in leave encashment and overtime provisions. Uh, can you also quickly cover that before we'll have other
Okay.
questions and waiting for Dr. Meena to join?
Sure, sure. So in general, overtime is a payment which is applicable when someone works beyond the normal working hours. Normal working hours is defined today also, it is defined under Shops and Establishment Act. It has been defined under the labor codes as well. Now we find reference of overtime, one in OSH code, other one in code on wages. What OSH code says that it is applicable to workers, and what code on wages says that employees for whom who are covered under the minimum wages, they will be entitled to overtime. That's a bit of anomaly in the language, or at least in the interpretation, considering the fact that going by the various documents from the government, what has been stated that under the minimum wages the concept of scheduled employment will not exist now, which typically would mean each and every one who is employed will be covered under minimum wages. So what is the relevance of having that wording there for employees who are covered for minimum wages is something where ministry has to come with some clarification. But at the same time, what is very clear by the law is that if you classify someone as a worker, right, a set of your employees who will be classified as worker, they will be entitled for overtime payments. And overtime payments has to be done at twice the wages. There are adequate rules around that. What is a normal working hours, what is how many hours of additional work someone can do, what will be the total overtime, what can be done in a quarter, in a month. Respective states have different rules. For example, the rules of Haryana are very flexible. A lot of inbuilt flexibility they have introduced, wherein people can have flexible working hours with they will work more on few days and some of the days they can take off. So that kind of provisions exist. Once we have clarity on the other part, the point on code on wages, the one part of the non-worker part will get clarified, and workers, the overtime mechanism has to be introduced considering the strict enforcement, the penal provisions in the new labor codes. You need to have policies around that and the enforcement mechanism to calculate overtime hours. And there are
Ankur, before you go
yes,
to the concept of leave encashment, I have one question on the overtime. If you don't mind, I ask you, or maybe once you finish, I'll ask that.
please go ahead, Akhil.
Yeah, yeah. So I think regarding overtime, the code provides for overtime to employee who are covered for minimum wages, as you rightly said. However, the concept of scheduled employment for minimum wages has been removed. So does this mean that overtime may be applicable for all the employees now, even for us?
Yeah, that is one of the view which comes out of it. But I would say this is an ambiguous area. The position is still unsettled. But at least for one class of your employees, it has to be paid. That is very, very clear. So what can happen there? Even though scheduled employment is removed, the government will still issue notifications for minimum wages. And how the law evolves, all of us will be witness to that. But if there are a category of employment which will be mentioned there, then a view can be taken only uh, those categories which are mentioned in the notification gets covered here. Only other point which I want to cover here is that overtime reference comes in Shops and Establishment Act, it comes in OSH code, it comes in code on wages. So again, a harmonization, a constructive reading of various documents read with the respective state laws is the need of the hour. We need to understand that. We, yeah, okay. We have sir with us, so
Yeah, yeah. Thank you, sir. We can understand
Yeah,
the pressing commitments you have. And I think the audience has been waiting for you, and you've joined at the right time when we've concluded all our slides. Now we have all the relevant questions for you.
okay.
But before coming to that, let me give a quick introduction about you to my audience. We are honored to have Dr. R G Meena, who is a former Deputy Chief Labor Commissioner and advisor to the Ministry of Labor and Employment. Dr. Meena has been involved with the ministry in various capacities over his more than 3 decades of experience. That's something commendable, sir. As everyone should be aware of that, he was instrumental in framing the labor codes and has deep insights into all aspects of this implementation. Sir, we are grateful for your presence and we are looking forward to receiving your guidance in today's session. As you know, today we have assembled to discuss about all the four codes. So without wasting any time, and I know due to ongoing parliamentary session, you have a pressing commitments and all. But thank you for taking time out for our audience. Now, can we have an overview from you on key impact areas such as wages definition, benefits like gratuity, PF leave encashment, provision for contract workers in core activities, guidance on notification of rules by center when the rules by center will be published and state for that matter, and roadmap for the organization for smooth transition to the new labor laws. I know I've asked you for, but I will repeat. But these are the things where we can get an overview, and then there are some specific questions. We'll come to that.
Right. Okay. Thank you very much. First of all, I feel my apology because it was scheduled at 4 o'clock and there were government exigencies, and I have no excuse but to attend that meeting because 3 calls came from my apex level in bureaucracy. Anyway, friends, so I'm also a human being like you. It is nothing special. We all learn every day in our life. So I got the opportunity to draft the code. I was a technical member and deeply known in drafting all the four codes and drafting the rules also. I was a member secretary for the drafting the rules also. Briefly, I will touch it. I know because after notification on 21st, everyone is eagerly reading the codes. Before that, I can tell you, very few people have read it. The draft rules were in public domain earlier also in 2020 and 21. We have received very limited objection and suggestions, which has been examined and incorporated in the codes and the draft rules. So friends, the code on wages, just briefly I will introduce you so that you should have a fair idea about the code. Code on wages basically subsumes the wage laws, and now we will have a universal minimum wages. This may be noted because every category of employee will be covered under the minimum wages, code on wages. Then we have to make payment on or before 7th. Earlier, the flexibility was there up to 10th, where the 1,000 and more employees were there. Then first time we have brought the statutory floor wages. This will balance the regional imbalances. No state government can fix the minimum wages below the floor wages. So it will balance the border states. Then we have made the employee definition very simple. So in code on wages, the employee means skilled, unskilled, semi-skilled, highly skilled, managerial, supervisor, all are employees. Most importantly, the threshold of 24,000 has been removed and there is no, as of today, wage ceiling for definition of employee. So every employee will be covered except the employers who are covered under the definition of employer. So code on wage again prescribe the provisions for the bonus. We have brought earlier, there was a provision for equal wages for equal work for women, but now we have brought the gender equality. So this is another reform we brought it. There cannot be a discrimination in the recruitment and payment of wages to the all the genders. So we have recognized the transgender also in the new codes, which was not there earlier. So first time we have brought that improvement notice, because till now, if any establishment is inspected, the inspector is issuing show cause notice to you, that is following the principle of natural justice. But now we have brought the amendment in the law, and it is mandatory for the inspector to give show cause notice to you, and you get 30 days time to comply. And once you submit the comply, then he will be duty bound to verify before taking any further legal action, which was not there at present. So that is the difference, because earlier show cause notice was given, but it was the discretion of the department or the inspector whether to give you opportunity or not. But now, if you have submitted the compliance report, I would request all the friends, whenever any inspecting authority is visiting to your establishment, if he is giving show cause notice, you get 30 days time, mandatorily comply it, ensure that reply is reaching to him. Now we are coming in the portal era, so all the inspection report and everything will be online through portal only. Now inspector will be inspector come facilitator. He will have a two role responsibility. Number one is for the guiding to the employer how to comply and make aware the workers about their rights created under the law. So thirdly, friends, in the code on wages, in the first offense, the imprisonment provision have been removed. Only penalties are there, and that too also compoundable. Now compoundable will be, if it is a repeated offense within 5 years, that will not be compoundable. In the first inspections, if you have failed to submit reply or something not complied, then again when matter is going before the authority or the court, you have one more option, you can go for the compounding. I want to explain you must have seen the Motor Vehicle Act. Whenever you are crossing the red light, you get a SMS message or the WhatsApp message on the mobile, you have violated the traffic rules, this, and if you want to compound it within 60 days, pay 1,000 rupees. Otherwise, a challan will be filed in the court, and then court will take cognizance of that. So this is a big reform we brought after 75 years in the labor laws. And this provision is there common to all four codes. So friends, improvement notice, decriminalization, and compounding has come part of all the four codes. Now, next coming to Occupational Safety, Health and Working Conditions Code. So I am not mentioning which are the laws have been subsumed. In brief, 29 labor laws have been subsumed in 4 labor codes. So instead of listing out the name and all, I don't want to go into that. I'm aware you are mostly concerned about the issues related to contract labor, what is the core and what is non-core. But briefly, I will tell you, OSH, we have been a big reform. In place of 8 registration, there will be a single registration. In place of 4 licenses, there will be a single license. License under ISMW is done away. Factory, PD cigar, and contract labor. Under contract labor, again, we have make a provision. Any contractor want to have an all India license, for example, any big organization, HCC or the LLT is working in more than one state, even in the state sphere, they can obtain license from central authority. So their officials are not required to visit some 10 licensing authority in the state, and the central will issue the license. Thereafter, the rest of the compliance will remain with the state government. So that will make ease of doing business to them. In the Occupational Safety Code, the standards at present are varying from state to state. I am aware, I worked in Mumbai for 5-6 years. I was in charge for the Maharashtra also and Nagpur also. Then I was in the Gujarat. Then I worked in Rajasthan also and Delhi also, Chandigarh also. There were 5 states under me. So each state is having different standards for the factories, plantations, etc. So now that was the call. And when we were drafting, we have a detailed discussion on that. So now standards will be uniform across country for the factory, for the docks, for the mines, for the plantation, for the building construction. So these will be common standards across. Similarly, you must have read section 23 and 24 of the OSH code, which prescribes the detailed provision for the health, safety, and welfare. These rules will also be drafted and finalized by the central government only, so that welfare facilities should be across countries similar, because working conditions are similar, so that there should not be any variation to that from state to state and all. So this has been a conscious decision by the government of India, and we have uh, already put the provision in the law, and the draft rules were just 3 months back. We have published in the public domain. Suggestions have been received, and we are scrutinizing that. Similarly, in place of 84 registers, now only 8 registers, and that too common to all 4 courts. There were approximately 31 annual returns now subsumed and only single return. Annual return will be only single. I told you inspector is again inspector cum facilitator in the OSH also. Compounding is there. Improvement notice is there. In the OSH code, there are certain provisions which are serious in nature of the violations, like related to safety or any fatal accident, serious bodily injury and all. In those cases only, if punishment is more than 1 year, those offenses will not be compoundable. The rest other provisions will be compoundable in first offense. In the code on wages, I told you the subsequent compounding will be after 5 years, but remaining 3 codes subsequent compounding will be after 3 years. So this is a difference. We have taken a further review on that. So compounding will be in 3 codes after 3 years. Similarly, friends, now come to Social Security Code. Social Security Code, we have combined the provisions related to PF, ESIC, gratuity, maternity benefit, employees compensation, etc. The most importantly, the definition of appropriate government is universe and common to all courts. So earlier, for maternity benefit act, the appropriate government was state except the mines and circus. Whereas now, and the payment of gratuity act, establishment having branches more than one state, central government is appropriate government. So friends, be very clear about that while working as a controlling authority or the appellate authority. I found that sometimes due to lack of knowledge or whatever reason, applications are filed at the state authorities, and when subsequently objection is raised, then they are coming to the central authorities. So definition has been retained that establishment having branches more than one state, the central government will be appropriate government for gratuity and maternity also. So PF and ESIC, you know, it is a central agency only. So for PF and ESIC, only central government is appropriate government. There is no concept of state government or appropriate government. So Social Security, again, benefits have been retained. Big reform we have brought in the definition of family. So Rajshri is here. Now in the code, your mother-in-law and father-in-law will be included in your family. They can get the treatment under ESIC. So that is the reform we brought it. And similarly, so many reforms we have brought it in that Social Security. There were a lot of litigations that when you are coming to the office duty and from office going back to the house, if any accident take place, this will be during the course of employment, and your family will be eligible for the compensation or whatever the Social Security benefits are there. First time we have recognized the gig and platform workers. Friends, let me tell you, when we were drafting, we have searched the entire world, and India was the first country to draft the code and bring in the main law the provisions related to gig and platform. Only USA, though, 2 states, one Florida and another, they were having the state legislation, not the national law. After the law was enacted, Honorable President assented and it was published in the public. Thereafter, because draft rules were there and there were various aspects, so code have been now implemented, but India, that time, India was the first country in the world which has national level make the law on gig and platform workers for their welfare, social security. Now, my knowledge, around 15 countries have their law on the gig and platform workers, and some states have also notified their law because central was little late. So, friends, there similarly for the unorganized worker, also government has make a provision for the board and the schemes and all, and detailed schemes, their benefits and all is provided in the code. I am not going much discussion on that. Then industrial relations code.
Yes, sir. Yes, sir. You can continue. I think, in interest of the time, if you can, quickly, then because we have four, five
But no,
questions.
just 2 minutes I am taking because
Yeah, yeah. After that,
over an idea.
we have three, four questions which needs your attention,
Yeah. Please,
and then we can
just
have your
let
concluding
me just
remarks.
2 minutes.
Yeah.
So industrial relations code, appropriate government definition is almost similar to the Industrial Disputes Act. We have added the metro railway, and another reform is that any public sector, if their stake of central government share is reduced from 50%, then also central government will continue. Number two, strike notice is made mandatory for all the establishments, which was earlier in the case of public utility service only, 14 days. Thirdly, whether you have notice or not, now the conciliation proceeding will start when the first conciliation meeting will take place. In the existing law, once the strike notice is received by the conciliation officer, conciliation proceeding deemed to have been started, but now after the first meeting, so that responsibility lies with the conciliation officer also. And I would request all my friends, be aware whenever any such notice comes, forward it to the conciliation officer and ensure that he is issuing conciliation notice before the date of strike, so that matter is seized in conciliation and your industrial peace and harmony is maintained. The moment conciliation proceeding is started, then service condition has to be maintained same, so strike union cannot resort to strike pending conciliation. Okay, friends, the rest of the provisions are the similar. I am not discussing on that. Now coming to Akhilji for your
Yeah. Thanks, Dr. Meena. I think very insightful for last 10 minutes. You were, the way you were throwing the positions and all looks like the kind of hard work and the kind of hours or years spent on this. And it has been inclusive. Whether it's gig workers or unorganized sector or platform workers who has been taken into. Even you've talked about transgenders and things on core activities but few things we want to have your view, and if you are not able to give the view, it's okay. I can understand, sir. As you know, because of the change in the definition of wages impact the retirees the way it should be, because as everyone knows, before this no code on wages, or definition of wages, there were different base salary which were considered in different acts. But now there's a uniform definition of wages which has to be used, and it can impact the retirees. So can employers undertake a compensation restructuring so that compensation structure is aligned with the new definition of wages? Is this okay? If the people can restructure their salaries internally?
see. We have a discussion in the law ministry also. Code have been notified on 21st of November.
Yeah.
So definition don't have any rule making. So what is the understanding given, as you must have read the PIB press release also.
Yeah.
There is always a transit period when any new law is coming and the old laws has to be repealed and all. So this is the period where the transit period is going on. So there are provisions in the General Clauses Act also and the other Parliament matters also. So those sections which have no bearing of drafting any rules have come into effect.
Okay, understood.
Okay, so that is very clear. Definition of wage, you must have read it, because remuneration, then basic, DA, and retention allowance, and the rest of the allowances A to I, 50% and above will be part of wages.
So the interpretation I can take, as you rightly said, this is a transition period, and people, if they want to do changes in the way the payroll looks like and the things
They
looks
can
like,
do it.
they can do it. Thank you very much, sir. And similarly for gratuity, because a lot of people have this thing in the mind that we are sitting on 2nd of December. If someone leaves, and as per the law, it has to be the last on salary or last on wages as per the new code. But the provision has been created in the books till 21st of November or till date also. And there are a lot of listed companies who are closing on 31st of December. They have been creating a provision as per the salary. So how they should look into it, but I think you clarified it's a transition time and central rules will get notified, and then that's how the methodology of doing it, grandfathering, not grandfathering, that clarification will come in due course. That's the right way to look into it, sir?
See, for gratuity, the provisions are very clear because we have to calculate the gratuity and the eligibility criteria. You are aware, 5 years of continuous service.
Yeah, yeah.
One point I want to clarify you for the benefit of all. If any employee completed 240 days in the 5th year, he will be eligible for gratuity.
Yeah.
So kindly take care. As an authority, I dealt a lot of claim cases. More than 1,000 cases I decided. So all variety of questions comes sometime. So that part you should take care. Fixed term employment, we have brought the gratuity proportionate on completion of 1 year of service. For consideration of 1 year of service, 240 days has been kept in the Social Security. But one major difference I want to highlight you, for the calculation of earned leave, the eligibility has been reduced from 240 to 180 days. If an employee has worked in the calendar year 240, in place of 240 days, 180 days, then he will be eligible for earned leave on 20 days attendance, one earned leave. So that is the difference. Then calculation method and everything we have written same, because this is a social welfare legislation, social security legislation, and there was no need to give any further amendment except the definition of wage. So the employer has their own teams, you have your management teams and all. So calculation has to be on the basis of last round wages, and wages has been defined in the law, and wages has no bearing of the any rules making. So law ministry has very clearly categorically mentioned the provisions which have a rule making shall be effective when the rules are finalized. It will be the government decision whether those rules will be effective from 21st November or from the date of final publication in the Gazette. Okay. Yeah, next please. Now
Yeah. So, sir, one more thing, but on the grandfathering or something, there any FAQs which are in the pipeline?
yes,
Or-
yes. See, we are continuously engaged. Let me tell you, friends, we have prepared the background note for every aspect, pros and cons, and uh, not cons much, but the benefits of the code for the employee, for the employer, and we are answering also. And FAQs are, we have already drafted, finalized it, and more FAQs will come. So I would request you, whenever you are getting any such FAQs and all, please forward it. There is a dedicated team here, so we will clarify it so that it should go very smoothly and there should not be any doubt and all these things. So that is the reason today I'm sitting with you.
No, no.
Yeah,
Thank you, sir. Thank you.
nation has to go on board.
No, no, sir, we are very much with you, and I think this is very encouraging. Everyone has accepted this as a change. Post independence, something has happened on the labor law, and biggest reform in that area. I think the government has worked for 20 years, so very welcoming. And sir, last two questions before we conclude the session for today. As we talked about, contract workers in the core business is now prohibited. You talked about that, and under current laws, only Andhra Pradesh has a similar provision as a state. We think establishment would need time to review and change the manpower composition, because there's a lot of outsourcing and contractual labor, and a lot of organizations, especially in manufacturing, has been using the contractual worker for core activities.
Good.
So your
Akhil
view
ji,
on this, sir, your thoughts on
no,
this?
I am fully aware. Let me brief you the entire audience. I begin the career from Mumbai, and after selection by UPSC, and when I was posted there, there were around 400 repetitions relating to contract labor,
Hmm.
and 80% were regarding prohibition of employment of contract labor. So I dealt it, I know the subject, and because in the existing law, there was a concept for prohibition of contract labor, there was a tripartite board. And that board will study and recommend it, and government may prohibit any employment which is a perennial nature, etc. And we are aware about it. See, you may be aware, Government of India has prohibited sweeping, cleaning, and watching of the building in the central government way back in 1976. That notification was valid till 2001, when the sale judgment Honorable Supreme Court says that now time is changing. We cannot force the establishment for such subsidiary services to engage the permanent employees. Okay, so and then thereafter there were a lot of judgments of the various high courts and Honorable Supreme Court. We have studied what you have mentioned, the Andhra Pradesh. I got that opportunity to examine in 2002, when the Andhra government has drafted the bill for the state government, and then we have discussed, we have in fact brought that copy also, and broadly provisions we have taken it. So now core and non-core is clearly defined, no doubt, no dispute, and no establishment should be panicked that we should go this way or that way. Your all system will continue. While defining the perennial nature of work, we have given you the windows. If you require for a short period, if you receive some order for the exporting any material, all drafting we did it keeping all the concerns of the employer, that let me tell you this much only. Okay. Simultaneously, the tripartite board has been removed. Now there will be a designated authority. If at all any question comes, that will be decided by that designated authority by the appropriate government. So nothing to panic about that. Whatever system is going on, only thing is your documentations and all should be proper. And we all are aware, we are moving towards the developed nation. We need employers flexibility, but simultaneously we have taken care ease of living the life also.
Yeah.
So wherever it was required, we have taken care. Now I will tell you, friends, why I told you you need not do panic. Because for the contract labor, health, safety, and welfare provisions rules will be drafted by central government only. Again, I am taking you to section 53. The welfare facilities will be provided by the principal employer only, like drinking water, latrine, urinals, canteen. Threshold of canteen has been reduced from a different scale to 100, and that includes contract labor. And if you read the section 23 and 24, for threshold purpose we have used the word worker. For the availing facility purpose we have used the word employee. So one has to read very carefully. While drafting the rule also in the ministry, I was known, in fact, very lighter way, friends. Now Minasa will teach what is the difference between the worker and employee. So
No, I think that's a story, very, and the rationale why this change has come and what's the story behind it, and you articulated it in a very subtle way, sir. My last question, before we conclude, uh, as you know, on leave encashment, earlier, the leave encashment happened only at the time of leaving the job, at the time of full and final settlement. But a change has come that if a person has more than 30 days, he cannot carry forward those leaves, that has to be encashed year on year basis. So, is there any transition period where the employer will be given
this
a,
I will tell you. Okay.
yeah,
See, while drafting also, there were different provisions in the different law. I don't have much time to explain you. Factories Act has one provision, Mines Act another, plantation, uh, working journalist, senior worker, etc., etc. So now there were different provisions. For example, the employee want to avail the leave, and when employer has not granted leave to him, then he will encash. So this provision has come that carry forward, because if you are accumulating, then also you have to run the industry also.
yeah,
So encashment is, you have to read it again, where the employer has denied the employee for taking earned leave. Okay. Again, the wage cushion and everything is there. So friends, let me tell you, taking questions on 4 codes and concluding the session in 15 minutes or half an hour is no justification. Let me confess honestly to the entire audience.
Nana sir, I think you will be amazed that we've overshoot by 15 minutes. We have more than 1,500 people joining us today.
Ji.
But still, we have 900 people with us. Even we have overshoot by 15 minutes because to hear you, sir. Now, your last words that when the rules by center and state will get notified, any guidance on that, and roadmap for organization for smooth transition to new labor codes, so that people should get ready. Your concluding remarks before we close the session. And you rightly said it's no winner that in 1 hour you can learn everything. We'll have more sessions depending upon your availability in the coming days, especially when the rules by center and states are notified.
Correct. So, friends, codes you have studied, draft rules were in public domain, so you must have studied, otherwise you started. Central rules are again coming. States also, almost all the states have, except 2-3 states, all have draft rules in public domain. And so that you kindly go through it. Once all the rules are notified for implementation, things will be very clear, but we should prepare the welfare facilities or the benefits which are coming from the code shall have a bearing depending on the provisions in the rules from the 21st. So that is very clear, and it is not only to ease of doing business, but it is ease of living of the employees also. We have balanced it. If you read it, the provisions by provisions, you will come to know wherever we have given the windows to you for interpret the law in a very flexible way or liberal way. This much only I can tell you, because I cannot cite you the examples and all, but we have make it like section for prohibition of contract labor. If you read it, at least 5 times you should read it. Then you will know what is exactly written in that. I'm not underestimating the IQ or your knowledge and everything, but let me tell you, because we have taken care, each provision has taken weeks time to finalize the word in the code, what to come, what not to come. And we were, let me share with you, we were the court committee members, one secretary sir was there, joint secretary myself. We have a one conviction, even in the midnight also you are getting some thought, put it in the WhatsApp and then sleep. Next day we will discuss it. So that we should not miss out. So the journey was like that, friends. There were 14 hours, 15 hours every day. There was no COVID. The day lockdown was declared, we were in the office till 9 o'clock. So, and thereafter, I don't remember for 2 years whether there was any Saturday or Sunday. So friends, but the nation was waiting for it, and hopefully employers will get a lot of relief from the new labor codes. Simultaneously, employees will also get benefit. I told you that I'm concluding, minimum wages will be across. Floor wages से कम कोई state government नहीं दे पाएगा. Social security for the unorganized worker, social security for the gig and platform workers, and the other benefits for the regular employees. Thank you very much.
Thank you very much, sir, for your time and detailed guidance by you and our speakers, Ankur and Ashli, on various topics which will help organization to comply with the law and get ready. And you rightly said the kind of hard work and everything, you can see the reaction of the people yourself. People are very happy to hear you.
Yeah.
And as we promised, we would come out with more such session with sir once the rules are notified. We are taking this promise with you on record in the public platform. And thank you very much, sir. Thanks to all the audience for their patience hearing. We have a lot of questions. I think more than 100 questions with us. We'll respond. We have your email IDs. We'll respond to you, and we'll send this recording and the presentation to everyone. Thanks once again. Have a nice evening. Looking forward to successful implementation of this new labor codes.
Right. Thank you very much.
Thank you very much, sir. Thank you.
Thank you.